9 a.m. We are going to call to order the Cybersecurity Commission. This meeting we're actually holding in a hybrid manner this time, with some members participating in person, others participating remotely via Zoom. Members, and for all of us members who attend these hybrid in person, mute your phones or mute your phone or your computers. And best thing is to not even enable your voice if you're in person. So, and other members, please mute your phones or mute your session if not speaking. And then what we'll do is start with the roll. If the clerk can take the roll.
Senator Coran.
Here.
Representative Bonner.
Present.
Representative Elkins.
Present.
Senator Fateh.
Here.
Representative Lucero.
Present.
Representative Nash. Senator Osmic. Senator Wickland.
Present.
6.
Excellent, thank you. A quorum is present. So thank you, everybody. And on our agenda today, so we've talked a variety of activities to get us moving through so we can have the most valuable conversations are really about how do we move from our open, what we can discuss publicly, and then how do we get as a body information from our state resources, IT resources, as well as our partners in the public sector and the private sector. How do we make sure that we can have the most uninformed, or not the uninformed, we're uninformed today. How can we have the most informed conversations about the most vital aspects of our security, both within state government and throughout the entire state? Today's, what our agenda is really looking at what are some of the draft legislation changes that we've talked about, enabling kind of what is a closed door session, along with the policies and procedures that we have proposed to enable that closed door session. I see most meetings that will have a public session, and then we'll move into a closed door session, and that's what we're here to talk about today. What I would like is to seek action as we move forward on the draft legislation, as well as the rules, and that way we can get those things taken care of. We do have a window for draft legislation to get it taken care of this session or before the session ends, and I think we should do that. So prior to moving on that, we do have we need a motion to seek a motion for the January 10th minutes. If we could, somebody make a motion.
Senator Coran, I would be happy to move the minutes from the 10th.
Excellent. Representative Bonner makes a motion. With that, any discussion? All those in favor say aye. Aye. All those opposed? Same sign. Motion carries. Minutes are adopted. So we have Ms. Weber here. She was going to give us an update on the proposed statutory changes, which we've all discussed, and I believe everybody has a copy of. And so, Ms. Weber, if you could present the changes in the legislation that we believe may be necessary.
Mr. Chair and members, my name is Michelle Weber, and I'm with the Legislative Coordinating Commission. I'll give an overview of the draft legislation, but I want to acknowledge the staff, both in the LCC and the House and Senate, that worked to craft this. They spent a lot of time putting this together, doing some research and so forth based on previous conversations. Emma Meyer in the LCC works with the Data Practices Commission, and she worked with Stephanie James, who's here today, as well as Nathan Hopkins, and other nonpartisan staff in the House and Senate on this proposed legislation, as well as the proposed rules that will be before you. In your packets, you have a copy of the draft legislation. Beginning on line 14, a subdivision is added to include a definition of closed meeting records, the information that is shared or maintained as part of a closed meeting. And then going to the second page of the document, beginning on subdivision 5, line 43, there's a deletion of language that shows up in the draft of closed meetings. So this is more of a technical change to reference closed meeting records. It also then, on line 45, indicates that the timeline for the Legislative Coordinating Commission to maintain those records and keep them private is at least 8 years. Then on line 46, you'll see up to no more than 20 years for the records to be released. This proposed language is a result of conversations that indicated in previous meetings that there may still be information 8 years from now that poses a cybersecurity risk to the state. Then on line 47, subdivision 5A is added, and this includes what the procedures, it provides direction to the commission about procedures that should be developed for closed meetings to occur and the minimum requirements that the closed meeting procedures must include. On line 50, there's a requirement to provide notice of a closed meeting occurring. Line 52, the second minimum item to be included in the closed procedures is to minimize the number of individuals who are present at a closed meeting. In item number 3 on line 54 indicates that the procedures must include action that the commission will take if there's an alleged violation of the confidentiality of information shared at a closed meeting. And then on line 56, the fourth item that has to be included in closed meeting procedures is guidance for the Legislative Coordinating Commission related to the public release of the records following that 8-year timeframe and prior to the 20-year period. So it includes information about what should be included in the procedures for the LCC to consider, because this commission will not be in existence at that time frame under the current statute. Then beginning on line 61, there's information about what would occur if there's an allegation of a violation of confidentiality by a member of the commission. And what this language does is indicates that allegation, if an allegation is brought before the legislative committee with jurisdiction over ethical conduct in either body, and that the committee with jurisdiction has the ability to preserve the confidentiality of information that might occur through that process. That was noted in a previous meeting that the ethics committees are the information can be public under that construct, and so wanting to make sure that if there is a circumstance that the information that's shared in a closed meeting doesn't inadvertently become public going through that process. So that concludes my overview of the proposed changes to the legislation.
Thank you, Ms. Weber. Members, any questions, comments, concerns? I don't see any hands in the room for both of us who are here in person, and I don't see any remote hands. With that then, members, I think it would be best for us to, one, that we've had it presented, we've all had an opportunity to read it beforehand and get the overview from Ms. Weber. I think we should agree, or I will entertain a motion, but I think it's best for us if we make a motion that we will adopt these changes, and then I think the next step would be, of course, have them drafted as an amendment for both bodies, and then have them introduced in the appropriate conference committee conversation so we can get this taken care of this session. Any members, any comments or concerns, or no? With that, I would entertain a motion that we would accept, or that entertain a motion to accept the draft statutory changes as presented to you, and for recommendation that we move them forward to be inserted into the the conference committee process in the appropriate committee.
Mr.
So moved, Mr. Chair.
Oh, Representative Sarah moves. Any conversation, any comments, concerns?
Yep.
I see none. All those in favor say aye.
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 All those opposed, same sign. Motion carries, and we'll move that forward. Thank you, everybody. All right, so now move on to the next step is really about the closed meeting procedures. I believe everybody has that document as well in front of them. And if we could have Ms. Weber kind of cover what she's gathered and collected all of our conversations of the past, much like the draft changes, utilizing best practices that are in place today, and then specifically as it meets or the needs are for our cybersecurity and the need for privacy, comfort, to make sure we can get the most open and honest conversation and secure conversation to occur between the vital people who manage our cybersecurity. So with that, Ms. Weber?
Mr. Chair and members, the document that I'll be speaking to has draft rules for closed meetings at the top of it. On line 5 of that document, the first section is just background indicating the statutory authority for the commission to have closed meetings. Item number 2 that shows up on line on 12 is an outline of what's contained in this, in this draft rule document. And then moving on to line 16, which is section 3, the definition and key terms. Closed meeting records, the definition here is consistent with the definition provided in the proposed statute changes. There's also a definition of commission, member, and presenter. Line 18 has the rules, that begins with the rules, many of which, what you'll see reflected here is also reflected in the proposed statutory changes. So on line 20, before a closed meeting can occur, there has to be public notification that a closed meeting will be occurring. And then also including on the next page, beginning on line 22, what are the grounds that are permitting the closed meeting, the subject to be discussed, and then a record of a majority vote of the commission that you will go into closed session, and then also an announcement of the date and time that the closed meeting will occur. On line 27, this reflects minimizing the number of individuals that are present during a closed meeting, indicating that only members and presenters may be present in a closed meeting. On lines 29 through line 34, that outlines the process for the commission to elect a secretary of the commission who would be responsible for the closed meeting records and taking the meeting minutes and then providing that information to the Legislative Coordinating Commission, which will protect the privacy of and the confidentiality of those documents. On line 41, confidentiality reminder will be provided at the beginning of each closed meeting. Whoever is elected as the secretary would read out loud that reminder to the members and presenters who are present in the meeting. On line 45, all members and presenters will be provided a copy of these rules before their first participation in a closed meeting. Line 48 indicates that any closed meetings are required to be in person, and attendance is required to be in person for a closed meeting. And then line 52 speaks to physical requirements. This gets to that members are encouraged and presenters are required to turn off or not bring into the closed meeting any electronic devices, including computers, cell phones, smartwatches, or similar technology. This was in result to conversations about the possibility of recording, unbeknownst to either presenters or other commission members, information that's being provided in a closed meeting. Moving on to page 3 on line 58, only the secretary is permitted to remove confidential materials from the closed meeting. Line 61 speaks to presenters, so they must inform the chair before a closed meeting whether they believe their presentation includes information that, if disclosed, would pose a risk to the state's cybersecurity. The presenter must store that information in a manner that protects the information, and if necessary, the presenter may also remove the confidential information from the meeting location. So in addition to the secretary, a presenter who's providing information could also remove information. Line 70 speaks to the procedures that the LCC must follow in terms of storing the records associated with a closed meeting. Line 75 speaks to the public release of the closed meetings. This is because the statute change hasn't occurred, and in the event the commission wants to adopt these today, this is crafted to reflect the 8 years. It does not speak to the 20-year time frame, but this provides that the LCC should do at its authority a review of the information and try to determine whether or not release of that information, if requested after the 8-year time frame, would compromise the state's cybersecurity. Line 87 speaks to the allegations of violations by members of the confidentiality and indicating that a report under review by a committee with jurisdiction over ethical conduct would prohibit a member from participating in a closed meeting. Under line 94, that just speaks to if a reasonable accommodation is necessary for an individual, either a presenter or a member of the legislature, to participate, that is to be reported to the chair, and then the chair can work with the LCC to make sure the appropriate accommodations are provided. So, Mr. Chair, that concludes my overview of the rules.
Excellent. Thanks, Ms. Weber. Members, comments? Concerns?
One question.
Representative Bonner?
Thank you, Mr. Chair. I know that we have, and certainly we want to be cognizant of not bringing in any potential recording devices, iWatch or iPhone watches, that kind of thing. But some of those items are things that we tend to carry on our person. Have we thought about at all if there's some option for storage of some of those items if they do carry with us?
Representative Bonner, yes, we've spoken to security, the Secretary and Capitol Security, as well as the State Patrol. And I do believe that we do need a facility, a secure facility, and likely security for the facility as well, physical security when we do meet. And that we should obtain those electronic devices and make sure they're in a secure, safe place. Absolutely. Absolutely. But I don't think it was necessary to define it here, as well as we are also have looked to what is the best facility. We're not going to highlight where those are, but we don't have a SCIF that's readily available for us. But we've talked about an interior facility, no windows, those types of things where, a $10 Radio Shack listening device cannot penetrate or listen in on one of our meetings. So, Representative Bonner, any additional comment?
That covers it. Thank you.
Senator Wickland?
Now, related to that section, letter F, I'm just wondering, is there a reason that we couldn't state that members are also required to turn off and rather than encouraged? Is there a reason that we're precluded from making that a requirement of members? It just seems like encouraged is sort of, I don't know, it sort of encourages ambiguity about what actually happens. And that seems like it could be a problem. So I'm just wondering if there's a reason that we can't state for our own members that they're required to, like presenters, to turn off or not bring in items.
Senator Wickland, I agree with you, and if we're going to go down that path, then I think it does say, please don't bring those devices. Shall we just update it, and if we can have a legal opinion, but we could modify it as such that they must either not bring those devices, so they don't have them. Likelihood is somebody has their cell phones with them, but that we will provide a secure facility to store them and make sure that they are, one, turned off, and two, that they're secured and stored in a facility outside of the meeting room where we meet. So would you be okay with that? Representative
Yeah.
Senator Wickland?
Yeah, if we can do that, I think that would be better. But if there's a reason that we aren't, that they aren't able to write it that way, I'd like to understand why.
Senator Wickland, I also agree. I think each person that we expect to have a great dialogue with will likely, in the rest of their world, whether it be the private sector, likely has far more stringent requirements.
Oh, and now we can't hear you, Senator Cran, or I can't hear you.
Oh. Senator Wickland, can you hear me now? Representative Elkins?
Yeah, your microphone is still off, Senator.
Senator Fateh, can we? Oh, hold on, members, hold on. Can somebody send a note out?
Yeah. Says your microphone
Oh,
is
wow,
not working.
actually, yeah, I was gonna say, I could turn this.
It says the
You're
microphone.
not showing muted,
Oh.
but can't hear you.
Yeah. Yeah, we don't have any audio from the room.
Can you call Julius?
Can any members hear me now, remotely?
I have no idea.
Members, can you hear me now? Except for the echo. Is your mic on?
How about now?
Could you check?
Members, can you hear me now? Nope.
Yeah, we can hear, it's more faint, but we can hear,
You can hear me now?
yes, we can hear you.
Okay. Sorry, it was the technology on this side, so. Looks like we got it taken care of. What's that? Okay. Excellent. If you could. We checked with legal, and we can amend that section on line 54 to 56 to make sure to clarify that members are required, not encouraged, but required to turn off their devices, and actually, if they bring them, we should require them to turn them in, and we will provide a safe, secure facility, a locked facility, as well as oversight to ensure privacy or the integrity or the safety of their devices. Ms. Weber?
Mr. Chair and members, I believe Senator Wickland, the amendment that you may want to propose would be on line 54, and it would be to delete the words "are encouraged."
Thank you, Mr. Chair. That would be, yes, I would agree. I would make that motion to make that change.
Senator Wickland moves to make an oral amendment to delete "are encouraged" on line 54. Any conversation? Questions? All those in favor say aye.
Aye.
Those opposed,
Aye.
same sign. All right, motion carries. Amendment is made. Anyone else? Any comments, concerns, members?
Mr. Chair,
Representative Bonner?
do we need to add clarification about turning those devices in for storage?
Mr. Chair and members, I'm just
Ms. Weber.
checking with legal, and Nathan Hopkins is also on. So Nathan, if you have any thoughts, I did just check in with Stephanie James here in the Senate. There was nothing that would prohibit you from putting those practices in place when you identify the meeting facility. That would require you to have language here specifically, but if you'd like us to work on some language, we could try to do that.
Representative Bonner, I think we should. We're going to distribute these policies and procedures beforehand for anybody that we would have participating or presenting to us. And so I think it's okay for us, if we're going to do it, it's our procedures. And so we're not writing law here in this particular case. But I think we do need to craft it as such that electronic devices, right, members turn them off, it almost nullifies the previous change. But that all electronic devices will provide an opportunity or provide a safe, secure place. However we do that, we will not use the term confiscate. But we do need to have those procedures clear that we will provide an opportunity for them to be stored in a safe, secure location. But we will leave the members shall turn them off, and then we'll provide a safe, secure location for the duration of the meeting, and then return to members or return to participants at the conclusion of the meeting. Ms. Weber?
Mr. Chair, I think that potentially the language you may want to consider, because of the unknown of the location, perhaps beginning on line 56, adding a new sentence that indicates that the LCC will develop options to provide a safe and secure location for devices during a closed meeting. That then would allow us to kind of understand what is the room, what's available, what might be available there. Is there something we need to purchase that gets brought to each of the locations, things such as that.
Thank you, Ms.
But
Weber.
giving us some flexibility.
And you're right, the facilities may vary as well. And so, members, any comments or concerns relative to that recommendation from Ms. Weber? If Ms., Representative
Mr.
Bonner?
Chair, I just want to say, I think that that would work, just something that's vague enough, but is clear on setting expectations for members and presenters who attend the meetings. I
Excellent.
appreciate that.
Thank you, Representative Bonner. And Ms. Weber,
Yes. And
I
maybe,
believe you have a suggested language.
I have
If
even
you-
better language.
If you could read that,
Yes.
and then we'll seek a motion to accept that language.
So, Mr. Chair, the language that would be added after the period on line 56 would be, the LCC will develop options for secure storage for members' devices during closed meetings.
Excellent. Thank you, Ms. Weber. Would somebody like to make the motion to adopt that oral amendment?
So moved.
Representative Bonner moves. Any further discussion? All those in favor say aye.
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 Those opposed, same sign. Excellent. Motion carries. Thank you, Ms. James and Ms. Weber. So, members, any other sections when you've reviewed? Senator Wickland?
Thank you, Mr. Chair. The only other question I had was back on the line 20 where it starts the before closing a meeting. Do we need to have any language in there about how much prior notice is required? I mean, it states that before the closed meeting, they must on the record do those. And during a public meeting, we would have to do those 4 things. But I'm just wondering if there's any need to clarify, if there has to be a certain amount of notice, or if it could be, because as I read it, it seems like we could, during a meeting, we could call for a closed meeting at that meeting that we're in. Is that what we want to have, or do we want it to be require any more prior notice than that? That's just a question I had about.
Excellent.
Otherwise, I don't see anything else that I had questions on. Thanks.
Thank you, Senator Wickland. Ms. Weber?
Mr. Chair and Senator Wickland, you may want to provide yourself the flexibility for the commission to make that determination. It's uncertain whether or not there might be a situation where during a meeting, a decision is being made by the commission to go into a closed session.
Thank you, Ms. Weber. And Senator Wickland, I tend to agree. I think as an outcome of one of our meetings, we may choose to have a brief private session. And I think, for our members, it may be, will we engage in that meeting, 15 minutes, 20 minutes, 30 minutes post our public portion of the meeting? Because we're going to literally have to move to a specific separate location. I do think we need to have that flexibility, but I think as we move forward, in order to make sure we always gain and secure public trust, we do everything that we possibly can out in the open, and to do as much public notice if we have a predetermined public or a closed-door session planned, to keep those up. And there may be occasions that arise where we have to do it in an unexpected manner, but we'll make notice during that particular meeting that we will have by an unscheduled but closed-door session to make sure we can share as much publicly as we can, yet try to maintain the privacy and security that's necessary or required. Are you okay with that?
Mr. Chair,
Representative Bonner?
question. I think that the expectation is generally that there could be a potential where we might have a situation arise during a meeting that would require us to close the meeting. But I know in the amendment we just looked at on lines 50, it suggests that there is a requirement to provide notice to the public before each closed meeting. Would an impromptu decision perhaps interfere with that line 50 and 51 of the amendment?
Ms. Weber?
Mr. Chair and Representative Bonner, the language on line 49 and 50 of the proposed statute changes says that the procedure must include that, and so then the procedure could include language that public notice includes a statement and a vote being taken during a meeting to go into closed session.
So,
Representative Bonner?
Ms. Weber, do we need to make an assumption or any kind of clarification that we will just automatically, as that matter of procedure, indicate that each and every meeting could include a closed portion? Just to cover our bases? I know I'm being a bit of a stickler on this, but I
Yeah.
do know that the public could, if we didn't disclose that it was a closed meeting, and then we later had to close a section of that meeting for security reasons, that could potentially create some folks in the public getting a little bit upset that they didn't receive notice.
Representative Bonner, I agree. I think, in Ms. Weber, I think for us on lines between 22 and 26, kind of the procedures of in order to have a closed meeting, if it's informational as well, but yet a public notice that's open and available to everybody, that to define that we will likely have, we'll certainly post all that we know, but on occasion, meetings may occur, and what constitutes public notice of that then closed-door session, which may occur during a Security Commission meeting, which we didn't previously notice or put on notice as a portion being closed. Ms. Weber?
Mr. Chair and Representative Bonner, we have some language from Ms. James for you to consider. It would be after line 26. When possible, the commission shall provide reasonable notice of the intent to close a meeting. The commission may close a meeting without prior notice when necessary.
Thank you, Ms. Weber, and thank you, Ms. James. If you guys don't know, Ms. James sneaks over and provides great guidance in real time to Ms. Weber. Thank you, Stephanie. With that language, members, any comments around that language, and would anybody like to make a motion to accept that language?
So moved, Mr. Chair.
Representative Bonner moves that language to be accepted as stated by Ms. Weber. Any comments or concerns? I see no hands. All those in favor say aye.
Aye.
Aye. Those opposed? Motion carries. Thank you. All right, members, any other sections? I think this has been a really good work session. I think we have a great document, so we can get moving forward in the most important pieces of this Security Commission's work. With that, I see no further comments. Would entertain a motion to adopt the rules that are proposed for our closed meetings.
So moved, Mr. Chair.
Representative Bonner makes the motion to accept the rules. Any comments, questions, or concerns? Seeing none, all those in favor say aye.
Aye.
Those opposed? Motion carries. Excellent. Thank you, everybody. With that, members, we are on, and I think in lieu of time, we will try to move on quickly. I know everybody has other obligations. Representative Bonner has to move on as well, and I think Representative Elkins does as well. Any current topics that you want to highlight now, or do you just want to send them on? We can have conversations about topics for the next meeting. We have obligations. I don't think we're going to have a worry about meeting our minimum obligations of meeting 3 times a year.
No.
I think when session closes, I think we should probably have a regular session. I think we have lots to get caught up on, as far as the education side, as well as having the closed sessions to get the vital information in the very purpose of this commission. So any particular comments on what you'd like to see? If not, if you're not prepared to share them now, just send them to me, call Representative Bonner, and we'll get those things on the next agenda. And then I see probably the first action would be, our first closed-door session would be with Minute to start out in kind of what can we want to exercise the process with Minute, and then to have a closed-door session to talk about kind of the state of cybersecurity and those things that haven't been shared with the legislature up to this point. So, any comments? Wow, excellent. Well, we'll continue moving on. I appreciate everybody's participation, Ms. Weber and Ms. James, and everybody in attendance. And then with that, I see no further meeting before us. We'll adjourn. Thank you, everybody.
Recording stopped.